First, I want to thank you all for having me here. It's an honor to be at this conference. So I will get right to it, given how the time is limited. So in my contribution, I researched how the rights and position of children taking part in judicial proceedings, either as victims, as witnesses, or accused, are interpreted in the case law of the European Court of Human Rights and of the Court of Justice of the EU. Now, historically, procedural rights of children who participate in judicial proceedings have received only limited attention in case law, and this case law is very fragmented. It's focused on specific issues. Mostly, the procedural rights of children are only a side question to the main issue at case. Of course, this can be at least partially blamed on the fact that the European Convention on Human Rights does not explicitly grant such rights to children, even though the European Court of Human Rights and the CJEU often refer to other international acts, such as Convention on the Rights of the Child, as we heard in the previous presentation. Regardless, there are certain important opinions which have developed in the case law which are worth examining. And from, the European Court of Human Rights established a while ago that children have the same rights as adults and they must be recognized as full rights holders, not the property of their parents. But they are also entitled to additional rights because they have special needs and they are especially vulnerable to being exploited or abused, especially when they are involved in different court proceedings, which is why the European Court of Human Rights did address certain issues. So these issues were they could mainly be divided in a few topics which are listed here. So the procedural rights of the child were discussed in the framework of the child's right to be heard in family matters, in the framework of the right to effective participation and access to a lawyer as part of the right to a fair trial. Another important issue was the representation of children before the European Court of Human Rights. This mostly refers to who can file a complaint on behalf of the child, for example, if the parents are not willing or able to do so, if their grandparents can do so, if some institutions can do so, and so on, and also some other topics which are listed there. Now, this presentation will only discuss the most important developments in the case law concerning the right of the child to be heard and the right to effective participation. And in conclusion, I will also shortly introduce how in Slovenia we have adopted certain measures recently that should help with that at least a bit, just as an illustration. The European Court of Human Rights, as far as the right to be heard is concerned, has adopted the stance that children must be sufficiently involved in decision-making processes which are related to their private and family life, and in that it referred to Article 12 of the Convention on the Rights of the Child and also on Article 24 of the Charter of Fundamental Rights of the EU. Now, the right of a child to be heard is not explicitly expressed in the European Convention on Human Rights. It's an unenumerated right. Instead, it is derived from Articles 8 and 6, depending on whether these are family proceedings or criminal proceedings. European Court of Human Rights stated that the right to personal autonomy, which is inherent to the notion of private life, signifies the right to make choices as to how to lead one's own life, of course, as long as this does not unjustifiably interferes with the rights and freedoms of others. Children can only exercise limited authority, not like adults, which they do through the right to be consulted and heard. Of course, their limited authority becomes more unlimited as they grow up, as they mature, and so on. For that reason, in any judicial or administrative proceedings that affect children's rights, children who are capable of forming their views must be provided with the opportunity to be heard and express their views. European Court of Human Rights has expressed in several cases that for children of a certain age, they prefer these children to be heard in person. However, when we have cases that involve young children, domestic authorities, for example, courts mostly, should obtain expert opinion on whether it is even sensible or possible, given the child's age and maturity, to interview them in person in court, and if the assistance of a specialist in child psychology might be needed to do that properly. If domestic authorities consider that the child is not capable of providing opinion, for example, if they are influenced by one of the parents too much, so their opinion would not be free, then the expert opinion can be obtained to replace this hearing of a child, even though this is not ideal, but still better than nothing. Similarly, in the case of traumatized children, an expert should also be appointed to determine if the child's best interest would be better served if the child was not heard in person and asked questions over and over again. It needs to be mentioned that the views of the child, of course, don't represent an absolute veto. They don't always override the parent's interest, for example, especially if the child avoids contacts. But the courts still have to try to gain this opinion. And there is also an opinion in the case law that courts must take into account the wishes of children when they reach certain age and maturity. For example, it would be pointless, sometimes even counterproductive or harmful, to force a child to conform to a situation they're trying to avoid. Like if we have a 15-year-old who doesn't want to have contacts with one of the parents, at some point and it can become harmful to go against their wishes. The Court of Justice of the EU has adopted similar stance. Basically, they said that it is for the court that has to rule in the case to assess whether such hearing is appropriate. Again, it can be counterproductive or harmful to question a child in person if that is not in their best interest. So the right to be heard is not an absolute obligation, but it must be assessed in each specific case whether it is in the child's best interest. I will skip this part, sorry. So, in criminal matters, the right to effective participation is part of the child's right to a fair trial under Article 6 of the European Convention on Human Rights. Basically, the European Court of Human Rights did not say that at some age children are too young to participate in trials, in criminal trials, but that the states should take full account of their age, level of maturity, and intellectual and emotional capacities, and that it is urgent to take steps to promote their ability to understand and participate in proceedings. This means that in the case of very young children who are charged with serious offenses, especially if they are subject to much media attention, it might not even be enough to get them access to a lawyer, which is self-evidentiary that it has to be done, and it's not even necessary that special measures that help them to understand the procedure are enough. The court has to also assess if they have the option, if they are uninhibited enough to actually feel comfortable to discuss their case with the lawyer and to cooperate with the lawyer effectively. This basically means that the authorities must take steps to reduce, as far as this is possible, the child's feeling of intimidation and inhibition, and they have to ensure that they have a broad understanding of the procedure. This does not mean that the child has to understand every point of law and every point of procedure, because let's be honest, even adults usually don't. When the cases are more complex, but as to quote the court, the authorities must take steps to reduce, as far as possible, the child's feeling of intimidation and so on, so that they can have a broad understanding of the nature of the investigation, of what is at stake for them, including the significance of any penalty which may be imposed, as well as of their rights of defense, and in particular of their right to remain silent. This means that if the child, for example, is not mature enough or doesn't have enough mental capacities to comprehend the importance of making a good impression, for example, on the jury, if there are jury trials, or if the child does not understand the meaning of being threatened with imprisonment, then they have to be tried in a specialized tribunal which can take account of these handicaps for a child and adopt its procedure. So rather than going through other rights that were discussed in details, I will shortly explain how Slovenia is trying to make up for those handicaps and to ensure both the rights to be heard and the right to effective participation in court proceedings. Now the first one is Barnahus. This is not specifically Slovenia, and you can see the map here of all the countries who are participating, either as members or just in the form of cooperation. But just to mention it for those who might not be familiar with it, the Barnahus model is basically the leading model in Europe for child-friendly, multidisciplinary and interinstitutional treatment of children who are witnesses or victims of sexual violence mainly. I will mention something about that for Slovenia in the next slide. This Barnahus means house for children. It's Icelandic. And the main point is to facilitate cooperation between different institutions, to bring them all together under one roof, so the child doesn't have to repeat themselves all the time, relive their horrible experience, and this should prevent some form of secondary victimization. One of the purposes is to collect valid evidence in a child-friendly manner, which can then be used in court. And if this is done properly, if all the necessary information is gathered from the child can even avoid going to court. The child can also receive other help and support, including therapies, health assessments, examinations. If it's necessary to examine their bodies, that can be done there with experts, so it's much more child-friendly than the court. Slovenia has had some developments in this field recently. So our first children's house was established in May 2022, and in the first year of functioning, as much as 26 children who were victims of sexual abuse were already provided with comprehensive care, and the experiences of people working with them said that it's a good way to go. And I would also like to mention, before I said that the main purpose is to take care of children who are victims of sexual abuse. Well, in Slovenia, since this year, Barnahus is also available to children who are victims of other types of violent crimes, not only sexual abuse. And it's also possible to provide treatment for suspects or accused who are underage if the court finds that to be in their best interest. We actually adopted this act that is listed here as legal framework with as many as 83% of our members of parliament voting for it and none against. And you can imagine that this is very rare that everyone votes for something. So how the treatment works? It starts with the court order in Slovenia, which means that the court still retains substantive procedural management of the questioning, but it leaves the implementation and organization to the children's house. Then the next stage is preparatory meeting, where the children is not participating yet. It's established which questions should be asked to the child, which facts should be clarified, and so on. And then the child receives an invitation to the interview, which is conducted in, you can see some photos here, it's conducted in a separate room with the help of an expert, usually in child psychology, who asks the child previously discussed question and is in contact with the court and with other participants through video conferencing. So everyone else is sitting in the conference rooms with a screen where they can see the questioning of the child, while the child is questioned from the other room. The questioning is also recorded, and it can be used as evidence in criminal procedure, which means that if they gain all the evidence necessary, the child doesn't have to go to the court. A child is also assigned a counselor who remains at their disposal throughout the treatment, so it's supposed to work nice, how nice it can be in these cases. In all the cases where Barnahus is not an option, there were several courts in Slovenia that have equipped special rooms for the hearing of children to reduce their stress as much as possible. These photos are from the district court in Maribor. As you can see, the room which is intended to hear the child is equipped with toys, with color books, with colorful furniture. It is separate from the courtroom where everyone can watch the questioning on screen. And very importantly, the child also has a special entrance, so they can avoid going through security, they can avoid meeting any other participants in proceedings. So this is also supposed to reduce stress. And this is in many of Slovenian courts for questioning of children when they can't go to Barnahus. Of course, this facilitates their right to be heard and also to effective participation. And some other measures that can facilitate effective participation are also materials with information which are adopted for children. These are screenshots basically from illustrated brochures that were published by Slovenian Supreme Court in 2010. These are activity books intended for children of different age groups, which explain in a very simple way what will happen to the child, who is a security guard, who is a judge, who is a prosecutor, what is expected of the child. It's clearly stated that the child did nothing wrong, that it's very important what they are doing, and that they are helping the court, that it's wrong to lie, and that they have to tell everything they know, but it's okay if they don't remember something. So it's very calming, and it also has a lot of fun activities where they do crosswords, where they connect the dots and so on. So it's trying to be as playful as possible. This, of course, helps them familiarize with the proceedings that are waiting for them, so it's a bit easier for them to know what to expect. More recently, Slovenian courts also went ahead with the times, so they published some animations which are available on YouTube in several languages, including Hungarian, because we have the minority there in Slovenia. So these animations also explain the process from the start, from meeting the security guide, from how the court looks, what will happen, and so on, so the child is explained everything. Now, of course, these are just some practical measures that I think are useful tools that we are using in Slovenia. More can always be done. And I think it's very beneficial to exchange different experience, to learn from one another, which is also why I'm very grateful to have been at this conference and to hear other interesting perspectives and experiences from other countries. So as I'm also out of time, I would like to thank you all for the attention.